And tonight on PM Express, fallout of the president's refusal to admit the anti-LGBTQ plus bill as Speaker of Parliament expresses frustration, describing the presidency's stance as setting dangerous precedents that will mar the integrity and functionality of democratic institutions. It's been 21 days since the bill was passed, and you may be aware that the presidency has issued a stern warning to Parliament not to make any attempt in submitting the bill for assent, citing two pending cases at the Supreme Court. Well, a co-sponsor of the bill has called on the Supreme Court to put an injunction on the approval of the president's ministerial nominee. So this is actually where we are. And it's been 21 days, just like I said, since that bill was passed, waiting the assent of the president. And if you look at what has happened, there are two pending applications at the Supreme Court for an interlocutory injunction to actually stop the president from assenting the bill. And this is where the Attorney General is coming from, advising the president and saying that assenting to the bill before the Supreme Court's dissemination could undermine the authority of the court, and also assenting the bill after the court's decision on the applications for interlocutory injunction rather is more appropriate. That's the advice from the Attorney General to the president. But of course, this Article 106 of the 1992 Constitution has come to play. And today, you heard the Speaker of Parliament reiterated earlier, former minority leader Haruna Idrisu had also raised this concern. And so it talks about notifying Parliament of decision not to assent within 7 days of receiving. That's Article 106. Clause 7 of Article 106. Now, if you go to Clause 8A of Article 106, it talks about recommending any amendment within 14 days of refusal. So if the president has any reason to refuse the assenting of the bill, he has 14 days to actually write to Parliament and give reasons and recommendations. And then it talks about Article 1069, which requires Parliament to reconsider the bill after the President has actually referred it back to them and minuted his reasons why he cannot assent. Now, Article 106.10 provides that the president has to assent the bill within 30 days after 2/3 MP support the bill. So if the president has issues with the bill, he has to write to Parliament reasons why he cannot assent. Then Parliament has to look at the recommendations. After they work on that recommendation and send it back to the president, he has 30 days to actually append his signature. So if you put the 7 days, the first 7 days that he has to assent the bill and the 14 days that he has to write to Parliament, that makes it 21 days. That's how many days the president has to actually say something about the bill. But has the bill reached him already? No, because the presidency is already warning the clerk to Parliament not to attempt to do so. So in Parliament, there's been conversations about why a pending injunction or interlocutory injunction should make the president not to assent a bill. And they give a clear example of the e-levy. The e-levy was passed in Parliament on March 29, 2022. The minority filed the case in the Supreme Court on March 30, 2022. On March 31, 2022, President Akufo-Addo assented that e-levy bill into law. And so the minority is challenging the presidency on this, saying that an interlocutory injunction cannot prevent the president from doing his constitutional duties. Now, you heard from former President Mahama, who's been speaking about this. He says that no religion in Ghana accepts LGBTQ activities. The President's Secretary has no authority to write such a letter, which was corroborated by the former minority leader, Haruna Idrisu. Parliament is obligated to send every bill to the President. And this, he says, is a threat to Parliament as an independent institution. Now, just like we've heard, Roxanne Nelson Dafiamakwan just like it was announced in Parliament a while ago by the Speaker of Parliament, he says that no court can injunct a president from performing his functions under the Constitution. So he has equally gone to court, and he says that the president's refusal to accept the transmission of the bill is not supported by the Constitution. That's what the Speaker is saying tonight, and statutory provisions that guide the legislative process. Allowing injunction applications to disrupt the legislative process has significant implications. The Attorney General did not advise the President against receiving the bill from Parliament. Indeed, if you look at the letter that was signed by the Executive Secretary of the President, Nana Santi-Bediatu, it stated what the Attorney General said. And indeed, there was nowhere in the letter where the Attorney General advised the President not to receive the letter. The letter says not to receive the bill, actually. The letter talks about the President not being advisable for the President to actually ascend the bill whilst there are two applications in court. So Roxanne Daffy-Amakpo is seeking an injunction to stop the Speaker from vetting the President's nominations, and the House will wait for the Supreme Court's decision on the injunction before proceeding with the nominations. In fact, this has gotten the majority talking. They are actually unhappy with this decision by the Speaker. So Afenyo Marking a while ago said that the Speaker delivered a speech without consulting the majority beforehand. The majority disagrees with the Speaker's position, and the injunction against the nomination of the President nominees was done in bad faith. Tonight, we're asking the question, what really is the constitutional provision on this whole confusion? The Presidency and Parliament are in this dilemma. We will be attempting to resolve that question tonight. I'll be joined by Roxanne Nelson Daffy-Amakpo himself, who has gone to court to seek for that injunction. He's a co-sponsor of the bill and a member of the Constitutional, Legal and Parliamentary Affairs Committee of Parliament. Habib Idris is the Deputy Majority Whip of Parliament. He will also be joining us in the studio. Also joining us for this conversation is Professor Ernest Kofi Abochi, who is Dean of the UPSA Law School. And later, we'll get to hear from the religious bodies. Very Reverend Father Clement Kwesi J will be joining us, and also be joined by Sheikh Arimayao Shaibu, who's a spokesperson of the National Chief Imam. PM Express is sponsored by Syntex Tank. It is strong, it is tough. Alomo Bitters, experience greatness in every moment. The Ghana AIDS Commission, Pepsodent, every smile matters. Let's have a conversation after this break. Welcome back to PM Express. And PM Express is sponsored by Syntex Tank, Air Strong, Air Tough. It's also sponsored by Pepsodent, the Perfect Smile. And of course, my name is Aisha Barham. You've been following what has happened in Parliament tonight. The Speaker of Parliament has been giving his verdict on the back and forth on the letter that is coming from the Presidency. I want us to listen to what he said in Parliament before he adjourned the House to go on recess. Then we can have this conversation.
The President's refusal to accept the transmission of the bill is, by all accounts, not supported by the constitutional and statutory provisions that guide our legislative process. The Constitution clearly delineates the steps to be followed once a bill has been passed by Parliament, mandating the transmission of the bill to the President for assent or rejection. Therefore, the refusal to even accept the bill for consideration falls outside the legal bounds established by our constitutional framework. It is incumbent upon the President to accept the bill and take the necessary action within the prescribed constitutional limits, whether that action is assent, refusal, or referral to the Council of State for advice or Parliament for reconsideration. It is instructive to note that the executive has in the past proceeded with its actions, although there has been pending before the court injunction applications against the state. Secondly, there must be a steadfast rejection of any attempts to unduly fetter or hinder the work of Parliament. The Parliament of Ghana operates as a crucial part of our democracy, embodying the will and voice of the people. Parliament embodies the sovereign will and power of the people. Parliament embodies the might and majesty of the people. And as I keep on saying, the power of the people is stronger than the people in power. Any efforts to obstruct its work, Parliament's work, disrespects this fundamental institution and threatens the principles of governance by consent and representation. Thirdly, it is imperative to remain vigilant against certain dangerous precedents that could potentially undermine the foundation of our democracy.
That was Speaker of Parliament Alban Bagbin, who was given his verdict on the president's letter. In fact, the letter that came from the president warning the clerk to Parliament not to make any attempt to submit that letter to the presidency for the president's assent, because there are two applications in the Supreme Court. Let me start with you, Reverend Father Jay. When this bill was passed, you expressed satisfaction and you said you were optimistic the president will assent to the bill. What's your appreciation of this new development between the presidency and Parliament? Hello, Reverend Father.
Yes, please. Thank you and good evening. Good evening.
Good evening to you, Reverend Father.
How are you?
I'm doing well, Reverend Father. Go ahead.
Yes.
So I was asking your appreciation of what has happened. I mean, at least when the bill was passed, I spoke with you on the same platform and you expressed how satisfied you were with the bill. And you said that you were optimistic the president will assent to the bill. Now we're hearing this, I mean, a banter between the presidency and Parliament. How does all of this come across to you?
Yeah, thank you. It is a bit unfortunate that this is happening. In fact, it was never foreseen that this occurrence would take place. But as a young democracy, we are growing. We are growing, and such are some of the experiences, the impediments that we encounter. It makes us grow in our law, makes us grow in our democracy. But we are not happy. I'm not happy what is happening, especially the two institutions, the two arms of government, legislature and executive. I mean, having this to and fro, this kind of conversation is not the best for us. But I'm still optimistic that in the long run, the bill will be assented to by the president. I think the president needs to reflect on his decision. And we also, as religious bodies, need to have a conversation with the president. But the way things are going, it is not the best. It is not the best. Because certain things are happening, actually. I mean, with the letter being written. You see, the Constitution is the supreme law of Ghana. And any law that is inconsistent with any provision of the Constitution for the sake of its inconsistency, it is void. You see, so how can you write a letter saying Parliament should not even transmit the bill to the presidency? I mean, you see, the law must be followed. Constituency, the constitution must be seen as the supreme law of the mother law of Ghana. The way things are going, it is not the best. And for example, I am not happy. And I think the Bishops' Conference are not happy. We must follow the law that the president swore to uphold. The president swore to uphold the constitution, to uphold the constitution, and we must go by that.
Right. So let's listen to the minority on this one. The minority leader, Dr. Atoforsen, has been also addressing the press on this, expressing how unhappy they are. In the studio, I have the Deputy Majority Whip, Habib Idris, who is with me here. I also have on Zoom Professor Kofi Abuchi. But I want us to listen to the minority on this one.
The Constitution of Ghana spells out in plain language when the President of the Republic of Ghana must do when Parliament passes a bill and present to His Excellency the President. The President must assent to the bill or must refuse to assent to the bill when it is presented to him as the President of the Republic. These are the only options, and in this case, there is no middle ground at all per the constitutional imperative. Ladies and gentlemen, let me also say that in the instance case of the Human Sexual Rights and Family Values Bill 2024, President Akufo-Addo has taken a strange and alien position, which is unknown to the Constitution of the Republic of Ghana. Given that Parliament has been injuncted in a matter of the President's nominee for the position of ministers and deputy ministers, it is obvious that this Honorable House is also unable and cannot approve those ministerial nominees His Excellency the President has also presented to Parliament. A call for Parliament to unite against the autocratic tendencies of our President and this government. We in the NDC minority is ready to protect the sanctity of the Constitution of the Republic of Ghana. And we stand with the Speaker of Parliament in this. Let the President of Ghana and his government be aware that where this country is going is strange under his watch. And the NDC minority will not countenance it. But I want to urge that it is obvious that His Excellency the President has breached the Constitution, and we will advise ourselves. In the coming days, don't be surprised that we will begin impeachment proceedings against the President. Thank you very much.
As Majority Leader Dr. Kasiel Atoforsen, Habib Idris is here with me. Your leader, Afenyo Marking, has been very unhappy about what has happened. He said that the Speaker made the ruling and adjourned sitting without consultation with the majority side. I mean, what's really your difficulty in understanding what the Speaker has done? Yes,
good evening. And in the first place, the minority leader assertion of what actually happened in Parliament is completely misleading and rather unfortunate. And I've been in leadership. This is my 4th year in leadership as a deputy whip. And this is not the way we always adjourn the House in a day, anytime a session or a meeting of Parliament is coming to an end. But today what happened is rather unfortunate because the Speaker was away. He arrived this afternoon around 12 o'clock that he arrived in the country. And then we had suspended sitting so that he could get ready and come. But when he came or he took over the chair, he read the statement. And after reading the statement, then he adjourned the House. That is so, it's very surprising and uncalled for. If you ask media houses, and normally any day we are going to adjourn, the procedure is always that when the Speaker presides, he asks us on the side of the government, because the majority leader is the leader of government business. Any business that is going to happen in the House is emanated from the majority side. So the Speaker is like a referee who sits there. So if definitely you are supposed to confide in the leadership of the majority to ask them if we have any business, then we'll be able to tell you whether we have business or not. And normally that when we are adjourning Senate, both majority leader and the minority leader will be allowed to give their closing statement before the Speaker give his own closing statement and adjourn the House Senate. But what happened today was rather unfortunate, and I think that it is a calculated attempt to frustrate government business. It is a calculated attempt to frustrate the government. It is a calculated attempt to use Parliament as a tool of denying essentially the good people of Ghana what they deserve. Because today, even before the Speaker came, we had engagement with the minority leadership. This morning, I was there as at 7 a.m. We had meeting, myself, the majority leader, the majority chief whip, the minority leader, the minority chief whip, and the deputy minority leader. Then we said, today we are adjourning Senate. What businesses are there from the majority side? So we told them the kind of businesses that we had. That has to do with, we were to do a motion on the health insurance approved formula. We told them that we were going to do the IDA loan, about 150 million for budget support, to be able to show our forests and to make sure that the city doesn't misbehave, especially with regards to what is happening now. And we also told them that we are going to look at the ministerial approvement and other things. So we judge or certain things, we agree from the, we started the meeting in the minority leader office, and then we moved to the majority leader office for us to be able to affirm things. Then we came in, we started the whole thing going on, and then in the middle of the whole thing, it's been disrupted by the...
Were you able to reach any conclusion after the back and forth?
Yes, we made headway, and we were able to agree to certain things, of which some of the things that we agreed we were able to do. Because in the meeting, we agreed that the health insurance supposed to bring some figures, and then they should bring it. If they bring it, we should be able to move their motion and pass it. And then they had concern with the IDA loan. If the finance committee meet and bring a report, generate a report, we should be able to pass it. So all that was done. And then with regards to the tax waivers we were going to talk about, because investors are now trying to run out of the country as a result of the fact that we are frustrating them in terms of giving them some tax holidays or tax waivers. So we agree the number of them that we're supposed to do. And they also told us that, okay, we'll be able to do this or that. And we started with that roadmap, because when we started, we were able to, pass the health insurance motion without any problem. We came to look at Road Safety Act and other things, and we did that. Then we suspended sitting to wait for the Speaker to come, only for us not to be given the opportunity, the majority leader, who is the leader of government business, to be able to give the business that he still have before we will be able to adjourn Senate. And that has to do with the IDA loan. That has to do with the approval of the ministers. And mind you, even though we haven't gotten into that issue, people are trying to tie in the approval of the ministers to that of the LGBT thing. It's completely different scenario. In fact, people, when I have a copy of Dafiamapo rate, it is completely misleading and rather unfortunate, because the kind of words that he used in there was never addressed to Parliament. Because if you look at Dafiamapo rates, if you come to look at declaration number 4 and 5, he said that number 5, that a declaration that upon a true and proper interpretation of Article 78(1) and 81A of the 1992, a minister of state and a deputy minister of state who appointment were revoked on the 14th of February 2024 cannot be reappointed. There was nothing like that of revocation of any appointment on the official letter the presidency transmitted to Parliament. There's nothing like that. I have a true copy of what was sent to Parliament. Whatever you see in the media that this person appointment was revoked, this person appointment was revoked and reassigned and here right now, that is not the official communication from the presidency to Parliament. So this one is just a calculated attempt to frustrate government and to frustrate the good people of Ghana what they are due. Because some of these things that we're supposed to do today would be able to help us bring potable water to the good people of various constituencies that don't have potable water, to be able to make sure that Ghana become clean, especially with regards to sanitation, and to be able to help us, especially that you see, I think yesterday somebody was telling me that a dollar to the city was around 13 point something percent. So if we were able to approve this, it would have been able to calm down things and let us move ahead.
So the declarations you talk about, I think that's for the court to determine. But you and I know that what has breeded all of this is the president's letter to, I mean, that's what has triggered all of this. What's the majority's stance on this? Because it was a unanimous decision for the bill to be passed, even though Afenyomakin had its own issues, but that was ironed out, and then the House unanimously passed the bill. Now we've reached this stage. What's the majority stance on this?
So you see, even the president's stand, people are misinterpreting the present idea of saying or present assertion of the fact that there is a injunction pending before the court. For that matter, I cannot proceed. The president is on record in a church to have said that he is against anything that has to do with those things. And the majority leader, Afenyomakin, when he was actually when we were doing the bill, the concerns we was raising typically was not saying that he is against the bill. Typically, he was saying that if you are bringing custodian sentencing on people who even advocate or relate or discuss or publish, if you like it, must face a jail time of 3 to 5 years. So he was saying that people reform. And if you are actually saying that because I am talking something or discussing something that has to do with LGBT, and for that matter, I should go to jail, will that let the person stop? But people have forgotten to realize the fact that, and it will interesting to you to know, if you ask prison officers, the number one community of places that they practice gay is the prisons. That is where it is. If you ask prison officers, and they are bold to tell you the kind of things that go into the prison. So the point is that the question is that if you are punishing somebody for that and you throw that person to prison, that's reform the person. So that was the assertion of Honorable Afenyomakin. That is off the table. So what the president was simply saying is that, yes, you have passed the bill, but I have been injuncted not to receive it. You, Parliament, have been injuncted not to transmit it to me. So whatsoever you are giving to me cannot. For instance, if I'm a member of Parliament, and in the Constitution that I cannot be served with a writ on my way from Parliament. So if I am on my way to Parliament and you want to serve me something, I tell you that, oh, hey, you cannot serve me because I have a constitutional, there's a constitutional provisions that actually protects me, or I enjoy this immunity as a member of Parliament. I have an error, or it doesn't mean that what actually is in whatever you are going to serve me, I am guilty of it. But I'm just stating the position. So procedurally, what happened with regards to today an adjournment, and then we are adjourning CNDA and other things, was rather unfortunate. And I think that the president, as we all know, is a lawyer of good standing.
But
and every law student will definitely read something about the president and kind of the
what the
things that
executive secretary wrote was to warn the clerk of parliament to desist from submitting the letter. What does the Constitution say?
No, he didn't. He did not.
I have seen.
That was not a warning.
I have seen the letter. It said that the clerk must desist. That's a warning. No. Aside that, okay, if you want to say those are semantics, what does the law say? Because there's been Article 106, which your colleague parliamentarians and lawyers are quoting for you. Article 106 states clearly that when Parliament passes a bill into law, the law will now be submitted to the President, who will have 7 days to assent to the bill. If he doesn't want to assent to the bill, he must have reasons for not doing that. He has 14 days to actually submit to Parliament with a note recommending and explaining why he cannot assent to the bill.
That is not exactly the case.
Why?
Then have you been able to read Article 90? if you read Article 91, that is not the only option to the president. Because if you read Article 91, the president even still have the right within the Constitution to refer the matter to Council of State. They can bring the bill to him, and the president will say that, okay, I have received your bill, but I have referred it to the Council of State. For them to, if they also have an amendment, they also have an advice or something, they will also do that within the same Constitution in Article 90. Okay. And also, the same Constitution that they are saying will also give the president the right. I think in 106 or 108 of the Constitution, that will also state that if whatsoever you are a bill that is emanating from Parliament that will put financial burden on the state must come from the Attorney General or the Executive.
There is no
and you
way
cannot be talking about jailing people where you think that there won't be financial burden.
There is nowhere in the Constitution where there is a provision that gives the Executive Secretary the right to stop the clerk to Parliament to actually send a bill that has been passed into law to the president.
But simply
can
what there is...
Can you point me to a law that gives him that authority?
No. What I can point to you is that the president or the Executive Secretary of the president also have the right to point to you that, look, hey, I have been injected. So stop bringing it to me because I have been injected. So what is wrong with that? Because if you read the letter clearly, let me see if I can get a copy of it. And if you read it clearly, the wording was more or less just to tell us that, oh, the president has been injuncted. So whatsoever you are sending, you should be mindful of the fact that, oh, yes, the president has been injuncted. So that is my understanding of the letter. I think I have a copy here. They said transmission of human sexual right and family value. They said it has come to the attention of the Office of the President and other senior officials of the presidency were at Peduasi for a cabinet retreat on the 14th of March. Your attempt to submit the Human Rights and Family Value Bill to Jubilee House for the president to signify his assent or otherwise of the bill. The office is aware of two. He's drawing the attention that, oh, I am aware that you have made attempts to serve us or to bring the bill. But we are saying that the office is aware of two pending applications for an order of interlocutory injunction, both filed 7th March 2024 at the Supreme Court. So that is 1 week after they said they made this attempt. So he was simply saying that, look, I am aware you are coming to serve me or to bring me this letter. But I am drawing your attention to the fact that I have been, or I'm aware there are two injunctions going on in court. So please, don't bring these issues to me again because I have been injuncted. As simple as that.
I have Article 90 here, and I'm going to read Article 91 too. For the sake of our viewers. But let me bring in Professor Kofi Abochi. I'm grateful for your time this evening. I just want you to help us clear the confusion here. Since the Constitution seems to be silent on whether the clerk to Parliament can be stopped from transmitting a bill that has been passed into law to the President for assent or not, Article 106 has been in contention here. Can you please help us understand what really is the letter and spirit of Article 106?
Well, first of all, to understand that, one needs to understand things broadly speaking. So broadly speaking, no one can direct Parliament on how it does its job. If you narrow that, it is only the courts who can direct Parliament in terms of its external compliance with the law. However, in the relationship between the organs of government, the principles or the theory that applies is what lawyers normally call the principles of separation of powers. Separation of powers implies that different organs are autonomous in their various spheres of influences and therefore their various provinces, but in their interaction, they are kept together by a concept called checks and balances where they check each other. So if you apply that in this context, the question is whether the executive can direct Parliament. And the answer obviously would be no. The executive cannot direct Parliament in the conduct of its legislative business. However, the checks and balances implies that sometimes cooperation happens between the various organs. Perhaps it is in that context at best that one can say that the executive may want to, as it were, nudge Parliament in a particular direction and hopes that Parliament takes the bait And if Parliament doesn't take the bait, then the executive can assert itself. It is a constitutional truism and a political truism that where the cooperation between the organs of government fails, each asserts its own authority, and in the process, there's a collapse of the machinery of government. The expectation of Article 106 is that when Parliament passes a bill, the executive may assent to the bill or may refuse to assent to the bill with an explanation of the reason for the refusal. And then in the back and forth between them, ultimately Parliament reigns. In other words, where Parliament sends a bill to the executive and the executive refuses to assent to it, and there's a back and forth between them, under the Constitution, where Parliament refuses to change anything in the bill for the third time, Parliament can pass the bill without the executive. Now, if you look at that from that angle alone, it tells you that the executive's participation in lawmaking is rather administrative. Some may even say perfunctory. Perfunctory or administrative in the sense that it is not that substantive. It can't defeat the legislative authority of Parliament. What it can do is to signify to Parliament that as the implementers of the law, if we have concerns, those concerns should be looked at. However, it doesn't defeat it. And so if Parliament, upon the third consideration, still decides that the executive's position is untenable, Parliament can proceed to pass the law without the participation of the executive. But it is a collaborative process, and the expectation is that they will not overrule each other and that they will collaborate or cooperate. And so at best, it is an administrative one. The passage itself begins and ends with Parliament, but then the assenting, which is the administrative component of it, is left to the President so that there is an executive participation in the process. So if you're asking for the broad statement of the principles, that's the intendment of Article 106.
There's been concerns about why the Attorney General must jump the gun to actually go advising the President not to assent the bill, even before the bill gets to the President. And I ask, is it not within the limit of his duties within Article 88?
Sorry, you have to take that again.
So the Attorney General in that letter, Nana Asante-Bediato, who signed the letter, says the Attorney General has already advised the President not to assent to the bill whilst there are injunctions in the court against the bill. And so he says that he should only assent it after the issues have been dealt with the Supreme Court. And before I even get to the injunction and whether that has any implication on the President's assenting to any bill into law, I want to find out if the Attorney General's attempts to advise the President is not within his remit as provided by Article 88.
Well, absolutely within his remit. The Attorney General is the chief legal advisor to government. So the Attorney General's job is to advise the government on the constitutional implications of various actions. It's important for us to remember, at least in this context, that the President can't be impeached if it is established that he has acted in a manner that violates the Constitution. So it is utterly imperative for the Attorney General to advise the President on the constitutional implications of key decisions the President wishes to take. Because those may have constitutional ramifications, especially as in this context, there is an issue of a potential court order or an injunctive relief being sought, which is pending in the meantime, that has consequences in law, and people understand this. So in terms of the Attorney General's advice to the President, obviously, that falls within the remit.
That's where I bring in these applications at the Supreme Court. What has it got to do, or what has it not got to do with the President assenting the bill into law?
Again, if I understand the interplay of things, it appears that as we all know, there's an injunction pending in court against the bill. So if I understand the context of the Attorney General's advice, obviously he's advising the President that because there is an injunction pending against the bill, and because in law, the consequence of the pendency of an injunctive relief is that the person against whom the injunctive relief is sought is supposed to refrain from undertaking actions that may have the effect of undermining the outcome of the application when eventually granted. So if I understand the context of his advice, obviously he's asking the president not to go ahead to sign the bill, since one of the reliefs that is sought is that the president should not sign the bill. And so if he does sign and the relief is granted in the end, he may have violated the application for injunction, which is pending against him. Again, I haven't seen the advice.
That's what I want you to clarify for us. What is the procedure? Has it got anything to do with Article 106, that when a court is when a case is at the Supreme Court seeking for interlocutory injunction to injunct the president and all of that, the president cannot go ahead to fulfill his mandate as provided by the Constitution?
Article 106 doesn't say anything about injunctions. I dare say that the Constitution doesn't appear to contemplate what is happening. And therefore, I would go ahead to even assert that this appears to be a major design flaw with the Constitution. It seems to expose major cracks in the structural framework of the Constitution. Now, first of all, the Constitution is designed on the principles of parity. So the three organs of government are equal. Nobody is above the other. But the courts have naturally enjoyed the power and authority of determining what the law is. And because the courts are given the authority to freeze things in time whenever there's a contestation over some particular matter before the determination of that matter, an injunction has always been used to freeze those things or those contested matters. Now, clearly we have a situation here in which an injunction is being used as an instrument of stultifying or blocking the performance of a constitutional duty by the president. And as I understand it, the minority has gone to court. The same is happening, in which case you have Parliament being stopped or stultified by way of an injunction from performing its functions. What may be happening here may be a decision before the courts to ask the bigger question on whether or not a constitutional actor can be stopped from performing a constitutional function by way of an injunction. Now, mind you, we've had this in the past. We've had the Electoral Commission, we've had other bodies injuncted from performing their functions. What I haven't come across in this case is the high-level executive, or rather high-level organs, which is the executive and the legislature, and who knows, the judiciary itself moving forward. So it's one that is novel, and I can say that the constitutional framers did not contemplate this, and it seems to expose a major flaw with the Constitution, because what we may have happening moving forward, if a proper position or pathway out of this is not developed, is that whenever we do not want someone performing his function, the functions of his office, we may simply decide to resort to the power of an injunction. And the critical problem being the mere application itself, the mere pendency of the application itself is sufficient to stop that particular agent or agency from functioning or undertaking the particular exercise or enterprise involved until the determination of the application. And so if the application is not determined for 2 weeks or a month, we may have succeeded in stultifying a major constitutional duty which is incumbent on an organ of government. And some people will argue that that is untenable. So it really exposes a fundamental issue that is worth examining.
Interestingly, one of the issues that have come up and indeed has been raised by the minority in Parliament is the fact that when the majority wanted to pass the e-levy law to actually charge people with e-levy, there was an injunction. That law was passed on the 29th of March. On the 30th of March, the minority went to the Supreme Court to stop it, to get an injunction for it not to be assented by the president. But on the 31st of March, the president assented to that law. That bill to become law. How do you juxtapose this, or how do you explain this? Because people say that's a two-faced, a double standard.
After such decision by the president, the same minority said that what the president did was wrong, that since there was an issue pending before the court, the president shouldn't have signed, the president shouldn't have waited. So granted that it was the case, now the president decide to listen, and the president decide to go by the process and abide by the law and respect the rule of law. What is wrong with it? Because in the initial process, he was definitely named, he was bastardized, that there was a case in court and he's the president, he was undemocratic, he went ahead and do that. Now he decided to say, let's say he's doing the right thing. And the right thing is the fact that there are 2 impending cases that is to his attention. And if we look at the letter, the Attorney General had advised the president that he has been duly served. So it means that it is not like the president is not aware. But unlike the e-levy one, there was no communication whether the Attorney General or the president was duly served on that matter. So if it was the case that the president was not served on the e-levy issue and he went ahead to sign, but he came under serious public attack by the NDC that he didn't do the right thing. Now he is aware and he has been advised by his chief legal advisor that, look, Mr. President, there is an injunction and I have been duly served. Then he said, I am not going to act on this until those constitutional issues are clear of. And the president, and I don't know why people are trying so hard to be able to tie the e-levy issue to the ministerial appointment. It is completely different. Hansard will bear me out, and we can actually be able to call for the record to the Hansard of Parliament. When the ministerial referral was done, I was in the chamber. Honorable Roxanne Dafiamapo, he rise to draw the speaker's attention, and he was on 3 issues. His issue was not the ministers that were referred and to be vetted, but he was of the opinion that he thinks that the Minister for Interior, the Minister for Works and Housing, and the Minister for Roads should have also been added to the list so that they will come for vetting. Because, mind you, the Greater Accra Regional Minister was moved to become the Minister of Interior, the Information Minister, Kojo Opon Nkrumah, to be the Minister for Works and Housing, and the Minister for Works and Housing, Asensi Boachi, moved to be the Minister for Roads and Highways. That was exactly what Roxanne Dafiamapo said in the chamber. He said, this is not the first time reshuffles have been done in this country. And the reshuffle that has been done in this country, they always move them, they don't come back for vetting. But when he is crafting and people are making the comments, and like I told you earlier on, saying that the president revoked some appointments and then the president reassigned people and saying that because others were revoked, then that means that they should appear before Parliament. I have a copy of the letter, exactly how the president addressed it to Parliament. And there is nowhere the president said that some people or some of the ministers designate that he has appointed, they should actually, they were revoked. And look, it was in part A. I didn't read the whole thing. I was just trying to say that the president just addressed it to the speaker. That's the official document that came to Parliament, not the one on social media. The president said that following the reorganization of government, I am writing to seek parliamentary approval for the following appointment into the executive in accordance with Article 78, 79, and 256 of the Constitution. And he do A, Ministers of State. Then it have the Health Minister up to that. Then B, Deputy Ministers of State. Then he mentioned all the Deputy Ministers of State. And then there was another column, he said, reassign ministers.
That's why I'm saying that.
So there was nowhere, but if you look at the
fine details that the court will deal with.
Exactly.
At least this is before the Supreme Court. So they will deal with it and come out with their judgment. But I'm going back to the fact that the president, you say the president has learned his lessons
no, the point is that
after assenting to the e-levy bill into law.
If it is not a cheap political point they want to square, can you just be able to explain to me how do you tie that the president have appointed ministers and did the right thing under Article 78, 79, 256 and referred them to and seek the speaker to refer them to the appointment committee of Parliament. They have appeared before the appointment committee of Parliament. They were vetted, scrutinized, questions were asked, a report has been generated. And then tell me, I don't get the mix-up.
My question is that
this is simply to tell you that the NDC attempt to frustrate what the Ghanaian people would benefit. The NDC attempt to frustrate the work of this government, the NDC attempt to score cheap political points and to frustrate the business of the house.
So your explanation is that the president has learned his lessons, and that's why he's learned his lessons from the e-levy situation, and that's why he wants to do the right thing. Then if that's the case, then the speaker is also doing the right thing by saying that we need to wait for the court to deal with this matter before we can continue.
But you see, the point is that if the president has been injuncted on the case of the LBGT, in this case of the ministers, it doesn't add up. How do you... The point is that Roxanne Dafiamopo is seeking the court to actually say that, okay, the person who has been vetted, look at the date he filed the writ. The vetting
it was on 19th March.
The vetting and the report has been laid. 19th March means yesterday.
Yesterday.
Good. Yesterday, we had laid the report of the appointment committee. As at yesterday, the report of the committee and the decision of the appointment committee was done, and it was signed by the chairman of the committee. The minister's one was laid. The report was generated on a majority decision. Later on, they meet, they discuss, and it came with a consensus decision. That of the deputy ministers, the report has been done. The chairman of the committee signed. Everything was done. So if you are now going to court to tell them that they should put an injunction on the vetting, of which you have knowledge that the vetting has been concluded, because the vetting was done in broad daylight. It was in television. People saw that those ministers and deputy ministers designated were vetted. The report was laid. He was in the chamber when the report was laid. So this is a pure mischief. This is a pure political propaganda. This is a pure political sabotage to the government. Nothing more, nothing less.
Well, your majority leader has been talking about how this will affect government business. I'll come back to that, but also remember that PM Express is being made possible by Syntex Tank. No matter your water needs, Syntex Tank has it all. Syntex Tank is first to introduce double-layer tank, and now you can have as many layers as you want. Syntex Tank is first to introduce white inner layer tanks in Ghana. We now introduce to you the customer specs order, which lets you order any color and size of preference. So whatever your water consumption, size of project or demand, choose Syntex Tank. We have agents nationwide. You can call Syntex Tank on 0244-335-168 or shop online at syntexgh.com. Pepsodent Cavity Fighter Toothpaste. Pepsodent Cavity Fighter is fortified with profluoride and microcalcium ingredients, sealing tiny and invisible holes in your teeth. It prevents cavities, keeps your teeth strong and mouth healthy. Don't just use toothpaste that brushes your teeth. Use Pepsodent that protects your teeth. Pepsodent is recommended by the Ghana Dental Association. Pepsodent gives you the opportunity to talk to a dentist for free. Call toll-free 0800-161-000 to talk to a dentist for free. You can get Pepsodent at any shop near you. Pepsodent, every smile matters. I'll take a break on PM Express. When I return, we'll be finding out. You heard Professor Abochi, who says that there's a lacuna in the Constitution because it did not envisage this kind of situation. How then do we cross this road? We'll be getting into that. And then I'll also be finding out what will this mean, or what are the implications of Parliament going on recess without finishing government business. What does it mean for government business? Stay with me. I'm coming right back. Welcome back to PM Express. We're still digesting what has happened in Parliament today. Speaker closing Parliament without the business of the House being done with, and the majority has been very angry with this decision. He says that they need to wait for the injunction on the President's ministerial appointees before that can be done. Let me ask you, now Parliament has adjourned, and you say that there are a lot of unfinished business. So what next for the majority?
Yes, at the moment it happened today, like I told you, unheard of, never done. There's no precedent to that. So after today, I think the majority caucus or the majority leadership, we will sit, because normally the government business comes from us, and we'll be able to engage the speaker And after we engage, then we'll see where we are going to go.
Do you have intentions to recall Parliament? I mean, to write to the Speaker that you want to recall Parliament?
It's within our rights, but at the moment we haven't gotten to make such a firm decision that we actually want to call back Parliament. But it is part of the options that we can be able to do. But what is necessary at the moment is for us to be able to engage and draw and build consensus around the whole thing, so that we'll be able, at the end of the day, we'll be able to arrive at a decision that will benefit the state. But what is actually unfortunate is that we, by this singular act, is trying to frustrate the government and even to leave other government organizations without ministers. For instance, if you come to health, both the minister and the 2 deputy ministers are all designated. They needed to be approved. So it means that apart from the fact that there is a caretaker minister on it, then the minister designated and the 2 deputies are not there. But if we had approved the ministers, these are very young ministers. These are ministers who are very serious, who were supposed to come and help the president to turn things around in this year. But this calculated attempt, the minority know very well that if we are able to pass this crop of ministers, a lot of positive things is going to happen in the economy. They know that a lot of things will happen. The other businesses that we have, that has to do with the IDA loan that I talked about, the 150 million. When it came, it was going to help in the forest in terms of the dollar against the cedi. It would have helped drastically. And apart from that, it was going to help provide potable drinking water, and sanitation issues are supposed to be in there. Then we also were going to look at the exemptions in terms of the businesses, because some of the companies that are working in Ghana need to be supported in a way to continue to exist, because some investors will want to move to other countries that are giving them equal opportunities. So if we fail to do that, we are putting them in a very bad position. And for that matter, the minority, well, when you see the speaker, after he said that the House was against Sinidia, you could see the jubilation coming from the minority side, our colleagues in the NDC. So they were just jubilating that, yes, we have frustrated the government business. Yes, we have. So that will not help Ghana. That is undemocratic. That is not patriotism. That is simply pure sabotage to the economic development of this country.
Professor Bochi, we all know the implications of a clash between the executive and the legislature. You have made it clear that there's actually a lacuna in the Constitution because the framers did not envisage this situation. How do we then cross this hurdle? Do we sit and cross our fingers and just wait for things to go the way it's going, or there's a way out?
The structure of the Constitution is based on the principles of checks and balances. So I think at this stage, it's important for cool heads to prevail. It is important for the principles of checks and balances to be activated. And a key aspect of the principles of checks and balances, as enunciated in the Constitution, is the idea of collaboration. So I do expect that the key heads of institutions, i.e., the Speaker of Parliament, and His Excellency the President of the Republic, I do expect that there should be some back-channel conversations already ongoing. It is important that the two speak and the two are ad idem or on the same page about this. Let's be clear. The exercise is not one of a confrontation between Parliament and the executive. Parliament is performing its legitimate business of lawmaking. The executive is asserting its legitimate influence of deciding whether or not to sign the bill. We may have issues with the letter, people may put interpretations, but anyone is entitled to, as it were, proffer ideas or proffer suggestions or give out opinions on particular things. So I would want to treat the letter purely as an opinion written from the office of the President to Parliament. Parliament can decide to proceed by sending the law. It is up to the executive to decide not to sign the law because of its interpretation. Now, my understanding is that the letter is probably trying to interpret the law, that in the circumstances of the pendency of the injunction, if the bill is brought to the office of the President, this is going to be the reaction. But the most important thing is all the organs are performing their respective legitimate functions and duties. I think we are at the point where perhaps the two organs of government should speak at the highest level, should engage and collaborate at the highest level, and see how we can have an exit point. Because none of these two organs wants to lose face. I think certainly not Parliament, because it is the lawmaking body. And because in the scheme of things under the Constitution, it is structured as the oversight body and as the one that supervises everyone, so to speak. Certainly also not the executive, because the executive is seeing this as its province to decide whether or not to sign. But the tug of war is not going to end well. In the end, government business is going to suffer, as we have already seen it play out from the beginning. And in the end, we may have a stultification of the entire process if you're not careful. We'll have things frozen because of injunctions and counter injunctions, and anyone can go to court. The problem about the character of injunctions and the principles of injunctions under Ghanaian law is that anybody at all can freeze anything by merely bringing an application to court. So whether or not the application is frivolous, whether or not the application is meritorious, before the court ever gets to hear it, the period within which the injunction has been pending before court is supposed to be a frozen moment. That is a problematic thing, especially in the context of constitutional law, because constitutional rights and constitutional mandates and obligations of government, and government in a broad sense, the various organs of government, constitutional mandates of these organs of government should not ordinarily be stultified by an individual merely activating the court process through an injunction. Unfortunately, because the Constitution doesn't address this, the general principles of injunction applies. And so once someone goes to court and caps the writ of summons with a request for an injunction with specific reliefs, whoever is implicated by the principles of law is supposed to restrain himself until the determination of the application.
This is what this is something that we'll be looking in the days going forward. We'll be looking at how this unfolds. Habib Idris has just indicated that they will speak with the Speaker and find ways of ensuring that government business goes on after he's adjourned Parliament. He said they have the power to recall Parliament. We'll see how this unfolds, and we'll also be monitoring the cases at the Supreme Court for interpretation by the Supreme Court. Grateful, Professor Kofi Abochi, for joining us. I'm grateful, Reverend Father Clement J, for also joining us. Thank you so much, Habib Idris, for passing through the studio. My name is Aisha Ibrahim. Do enjoy the rest of our programs.